Good morning, everybody. This is No One Unscripted. And if you have landed on my page, remember to like and subscribe. Just had to say that. I come on almost every day now. I hope that I don't have to continue coming on every day, but I feel compelled. And I don't know, there's something inside that keeps on telling me to keep doing it because maybe a dozen people watch, maybe half a dozen like, and it's thankless, and that's all right because even if I am documenting what is happening for the sake of history and for the sake of a handful of people, then and if the way that I explain what's happening helps somebody understand, even if it's one person, I feel that I am successful in my purpose to inform. So if you land on my page and like what you see, like and subscribe. And if not, you're never going to know I exist, which is fine. So today I will start talking about uh, the full appeal of the Justice Department of Judge Cannon's special master order. And there are uh, the arguments are repetitive, and they are the same arguments that the DOJ has presented many times over in many ways. And but this nonetheless, this appeal is important to read and explain the parts that I find to be important, simply because this is the full appeal of the special master case to the 11th Circuit. Once the once Donald files his reply, then I believe that DOJ will have a chance to respond to that reply, and then the 11th Circuit will set the timeline for the oral argument. So I want to just go, clip by clip that I found to be interesting to sort of give whoever hasn't been following this an idea of what's happening. The district court erred by exercising equitable jurisdiction in this case. The exercise of such jurisdiction over pre indictment criminal investigation is limited in exceptional cases, and it requires at minimum a showing that government callously disregarded plaintiff's constitutional rights. That hasn't happened here. A district court's exercise of civil equitable jurisdiction to constrain an ongoing criminal investigation prior to indictment is limited to exceptional circumstances. That is consistent with the familiar rule that courts of equity do not ordinarily restrain criminal prosecution. The factors that are weighed in considering whether equitable jurisdiction should be is appropriate are: one, whether the government has displayed a callous disregard for constitutional rights of the plaintiff; two, whether the plaintiff has an individual interest in and need for the material; and three, whether the plaintiff would be irreparably injured by denial of the return of property, and whether the plaintiff has an adequate remedy at law. And I'm kind of laughing with this one a little bit because I I kind of messed up in reading the 1, 2, 3, 4, and I remember reading the same thing in one of the other briefs, and it's kind of like repetitive, but I feel that we all need for this to be drilled into our heads in as many ways as possible. The blatant criminality and just reckless disregard for the rule of law that Donald has displayed throughout throughout. At least he's consistent about having a reckless disregard for the law. You know, plaintiff's uncontested failure to satisfy the first factor, which this court has described as foremost and even indispensable, is reason enough to conclude that the district court erred by exercising jurisdiction in this case. Then the in explaining that there has not been a callous disregard for Donald's constitutional rights, the DOJ explains how it first sought the records through voluntary requests, then it obtained a subpoena, and only when investigators learned that plaintiff's response was likely incomplete did they seek a search warrant. A magistrate judge issued that warrant after finding probable cause based on the government's lengthy affidavit. The evidence of multiple criminal violations would be found that evidence of multiple criminal violations would be found at plaintiff's residence. The records at issue here are the documents recovered pursuant to that court approved warrant after earlier attempts to retrieve them had failed. And the district court accordingly determined that plaintiff had demonstrated no callous disregard of his rights. So the absence of this indispensable factor in the Ritchie test is reason enough to conclude that the district court abused its discretion in exercising equitable jurisdiction here. And I think that the DOJ is just reading, is just, using the 11th Circuit's own ruling in the special master ruling that it issued, I think, last week. Because it is the same. I mean, the argument is the same. But I think there is a little bit more here in terms of explaining why equitable jurisdiction is invalid in this case and why the 11th Circuit has appellate jurisdiction. So this is all very jurisdictional and technical and meant to confuse the layperson. But the DOJ has done an excellent job of explaining it in simple terms. And I'm effectively just reciting that for you and pointing that out. Although the court had occasion to address only the district court's exercise of jurisdiction with regard to the documents bearing classification marking, the same analysis applies to all seized materials. The second Ritchie factor, Ritchie or Ricky, I don't know, considers whether the plaintiff has an individual interest in and need for material whose return he seeks. Plaintiff has no individual interest in any official government records. The government retains ownership, possession, and control of the records, and records bearing classification markings in particular contain information that is owned by, produced by, or for, or is under the control of the government. Moreover, plaintiff made no showing of a need for the return of any personal documents that were seized. He just wants to know Donald just wants to know what the DOJ is doing exactly with all of the information, so he can make preparations accordingly. He's now in the dark when it comes to the direction the DOJ is taking. And other than delay and compromising DOJ's investigation, this special master review has really no other real purpose. And that is becoming ever more evident in each successive filing by the DOJ, and by the fact that Donald got rejected by SCOTUS and lost the 11th Circuit partial appeal by the DOJ. And these are all indications of what's coming. It's just predictable. It's a matter of time. The third Ritchie factor asks whether plaintiff would be irreparably injured by denial of the return of property. Plaintiff has failed to establish any injury, let alone any irreparable injury, caused by his being deprived of the materials. And the injuries described by the district court, far from constituting exceptional circumstances justifying equitable jurisdiction, were both wholly speculative and could be claimed by anybody whose property was seized in a criminal investigation. So, district court noted that the government filter process was closed off to the plaintiff. That is not extraordinary. It is well established that filter teams, also known as taint teams, are routinely employed to conduct privilege review. And the use of a filter team is a common way to sift through the wheat from the chaff and constitutes an actionable, respectful of, rather than injurious to, the protection of attorney-client privilege. And this is precedent from the federal circuits, the 6th and the 11th. Additionally, Donald's lawyers were given contact information of the filter attorneys. The filter team had finished the review and was prepared to provide Donald's attorney with copies of all potentially privileged materials when Judge Cannon issued her preliminary notice of intent to appoint a special master. So before the DOJ, before Judge Cannon issued her preliminary order that was prejudicial to begin with, that said she's inclined to grant a special master, before even giving DOJ the chance to reply, DOJ had already finished their filter team review process and was ready to provide the materials to the court and to Donald's counsel. But the filter team was put on pause out of deference for the court's proceedings and sought the court's permission to produce the materials to Donald's lawyer. But the court reserved its ruling upon request. So this idea, and there has been, and DOJ talks about it in the brief later, that there's no showing that the filter team process or Judge Reinhart's warrant, any of that is wrong or at fault here. There's been no showing of that. Donald has not made even one showing of that. The district court also referred to plaintiff's supposed injury from the threat of future prosecution. But as this court already explained, if mere threat of prosecution were allowed to constitute irreparable harm, every potential defendant could point to the same harm and invoke the equitable powers of the district court. Essentially, that would upend criminal procedure. The fourth Ritchie factor is whether the plaintiff has an adequate remedy at law. And of course, Donald has an adequate remedy of law if he wishes to contest the legality of the search or assert any claim of privilege through ordinary motions practice in a criminal proceeding in the event that charges are filed. Mind you, charges have not been filed yet. We've been through this many times. But absent extraordinary circumstances, prospective defendants cannot, by bringing ancillary equitable proceedings, circumvent federal criminal procedure. This is a DC Circuit case from 1987, citing precedent of the circuit. And circuit court precedent is persuasive precedent. Like other circuits' precedents are persuasive on the 11th Circuit, but not binding. It's heavily persuasive, though. 11th Circuit's opinions, of course, they can overturn themselves, and is binding on all the courts that is within the 11th Circuit. But circuit court opinions are also given great deference by the Supreme Court. Finally, other factors that the district court considered have no basis in precedent and cannot justify the exercise of equity jurisdiction. Certain of these factors, such as the power of imbalance between parties and plaintiffs' inability to examine the seized materials, are hardly extraordinary, and it exists whenever a lawfully obtained search warrant is executed. To the extent the district court suggested that the plaintiff's former elected office entitles him to treatment different from that afforded to any other subject of a court authorized search, such a notion would be contrary to the public interest and the rule of law. This, I had to read this. I don't recall the DOJ saying this in other filings. This is the DOJ saying that Donald Trump is not above the law. Donald Trump is not special when it comes to the eyes of the law. He's a private citizen, and he is not afforded these privileges that are afforded to the executive of this Article 2 branch of the US government, which is the presidency. And I think it's done in a very dignified way. I'll read it again. To the extent the district court suggested that plaintiff's former elected office entitles him to treatment different from that afforded to any other subject of a court authorized search, such a notion would be contrary to the public interest and the rule of law. Excuse me. That is strong. Even if the district court properly exercised equitable jurisdiction, it erred by issuing an injunction preventing the government from using any of the lawfully seized materials in its ongoing investigation pending the review by the special master. For a preliminary injunction, plaintiff was required to establish a substantial likelihood of success on the merits, irreparable injury suffered absent an injunction, and threatened injury to plaintiff would outweigh whatever damage the proposed injunction may cause the opposing party. And number 4, that an injunction would not be adverse to the public interest. Plaintiff does not satisfy those requirements. About the success on the merits, plaintiff has no plausible claim of executive privilege, nor has he attempted to describe any that could bar the government's review and use of any of the seized records, classified or unclassified. Plaintiff has failed to establish any irreparable injury he would suffer from permitting the government to review and use those records not already segregated by the filter team. By contrast, the government and public interest are harmed by the unprecedented injunction and order entered by the district court. And an infringement, this is an infringement on the executive branch's core executive functions. Plaintiff has no plausible claim of executive privilege that could justify restricting the executive branch's review and use of seized records in the performance of core executive functions. Plaintiff has never even attempted to substantiate such a claim, and any such claim would fail for multiple independent reasons. Executive privilege exists for the benefit of the president, does not exist for the benefit of the president as an individual, but for the benefit of the republic. Consistent with the privileges functions of protecting the executive branch's institutional interests, the privilege may be invoked in certain instances to prevent the dissemination of materials outside the executive branch. Neither plaintiff nor the district court has cited any instance in which executive privilege was successfully invoked to prohibit the sharing of records or information within the executive branch itself. Remember this from previous filings. Although the court has stated that a former president may be able to invoke executive privilege after the conclusion of his tenure in office, it readily rejected the argument that the privilege could bar review of records by personnel in the executive branch sensitive to executive concerns, meaning the DOJ, the FBI, and anybody uh, involved in the um, justice, the investigative and prosecutorial sides of justice. Indeed, circumstances here dictate that these records will be treated with heightened sensitivity. They were seized pursuant to a search warrant in a criminal and national security investigation. They were in the custody of the FBI, and they must be safeguarded as evidence, including through appropriate chain of custody controls. Further, the seized records bearing classification markings must be stored in approved facilities, and officials reviewing them must possess the appropriate level of security clearance and must have the requisite need to know. The review, so and this is talking about, this is coming from executive order, from an executive order. Here, the DOJ distinguishes between what happened, the seriousness of what is at stake in this investigation versus that what happened in Nixon v. GSA, which is a huge precedent that is followed in this case. The purpose of the executive branch's review differs in GSA in the sense that the review at issue there involved the screening and cataloging of presidential records by professional archivists to carry out a statutory scheme designed to preserve the materials of legitimate historical and governmental purposes. Here, the review is being conducted by law enforcement and intelligence officials as part of an ongoing investigation for the purposes of assessing the potential damage to national security posed by the improper storage of the records with classification markings. But that distinction only weakens any potential claim by plaintiff. The execution of criminal laws and the protection of national security information are core executive branch responsibilities under Article 2 of the Constitution. The effective and expeditious performance of those functions serves compelling public interests. Again, compelling. Restricting the executive branch's access to information needed to carry out those functions would serve neither the purpose of executive privilege nor public interest, because the executive privilege serves the office and the presidency and the Constitution, not the person. In the Nixon court, the court concluded that generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial. So I wanted to again remind you about the specificity requirement. You'll see this at every legal proceeding, and you don't really hear this on Law and Order. The specificity requirement is the backbone, the spinal cord of legal proceedings. Okay, so, and in this brief, the DOJ explains the need for the demonstrated specific need. Okay, that demonstrated specific need standard has since been applied in the context of investigative proceedings as well. Okay, here the government plainly has a demonstrated specific need for evidence recovered pursuant to a warrant based on a judicial finding of probable cause. As explained, that is so as both the records bearing classification markings and the remaining seized records, meaning the ones that are in process to be reviewed by Judge Deary. The government's need for the records bearing classification markings is overwhelming. It is investigating potential violations of unauthorized retention of national defense information. These records are not merely evidence of possible violations of that law, they are the very objects of that offense and are essential to any potential criminal case premised on the unlawful retention of materials. Likewise, these records may constitute evidence of concealment or removal of government records. The records bearing classification markings may also constitute evidence of prohibiting obstruction of a federal investigation. And the DOJ explains why, because of the insistence over and over by the DOJ to return the documents, and Donald lying by way of Christina Bobb and Evan Corcoran that after a diligent search was conducted, all of the materials that were turned over were all that they had. As evidenced by the government's execution of the subsequent execution of the search warrant, all responsive documents did not in fact accompany that certification. More than 100 additional documents bearing classification markings were recovered from plaintiff's Mar-a-Lago club. Those documents may therefore constitute evidence of obstruction of justice. Okay? The government's compelling need for these records is not limited to their potential use as evidence of crimes. The government has an urgent need to use these records in conducting a classification review, assessing the potential risk to national security that would result if they were disclosed, assessing whether or to what extent they may have been accessed without authorization, and assessing whether any other classified records might still be missing. So essentially part of an ongoing criminal and national security investigation. So the need is not just that they're evidence of crimes, but that they're also part of the investigations going into not only those crimes, but other crimes and also national security concerns about what may have already been compromised. And I read you a footnote in one of the previous episodes about how the intelligence community assumes that something that is this classified, that has been left out and out of their strict procedures, is considered compromised until their assessment can prove and certify that it was not compromised. The district court itself acknowledged the importance of the government's classification review and national security risk assessment. Remember that even in the original order, Judge Cannon said the national security review could continue. She didn't go as far as to overreach completely into executive core functions. She just impeded it, The government has further explained, including through sworn declaration by the Assistant Director of FBI's Counterintelligence Division, why those functions are inextricably linked to its criminal investigation. So, talking about how it would be exceedingly difficult to conduct the investigation hamstrung. The government also has a demonstrated specific need for the seized unclassified records. The FBI recovered these records in a judicially authorized search based on a finding of probable cause of violations of multiple criminal statutes. The judge magistrate thus necessarily concluded that there was probable cause to believe those items constitute evidence of a crime or contraband, fruits of crime, or other items illegally possessed. In short, the unclassified records that were stored collectively with records bearing classification markings may identify who was responsible for the unauthorized retention of these records, the relevant time periods in which records were created or accessed, and who may have accessed them or seen them. So, in order for you, essentially, the DOJ here is saying, in order for the DOJ to conduct a full comprehensive investigation, and in order for the intelligence community to conduct a full and comprehensive assessment, national security assessment, they need this hamstring to be cut off so they can do their business without judicial overreach. The plaintiff's effort to block the executive branch's access to records bearing classification markings is inconsistent with the established principle that the incumbent president has sole authority to control access to national security information. It's the court in Egan explained that the president is the commander in chief of the Army and Navy of the United States, and his authority to classify the control and access of information bearing on national security flows primarily from this constitutional investment of power. The authority to protect such information thus falls on the president as the head of the executive branch and the commander in chief. This authority to protect and control access to national security information falls on the incumbent president as commander in chief, not on any former president. Supreme Court precedent here. Yet, plaintiff effectively seeks control which executive branch personnel, if any, can review records marked as classified and on what terms. This he cannot do. So, calling Donald out here. The authority rests with the incumbent president and the discretion of agencies to whom the president's authority has been delegated, meaning, in this case, the FBI, the DOJ, and that. And, we have a special guest. I'm not going to pay attention to the special guest because if I do, I will lose all train of thought and he will not go away. But as you can see, he's sitting there. And I think currently he's looking. Is he looking? Are you looking? Hi. Baba. It's working. Second, plaintiff failed to assert executive privilege when his custodian was served the grand jury subpoena requiring production of any and all documents. He didn't assert executive privilege. He didn't assert executive privilege several times, many times over. Nor did plaintiff move to quash the subpoena on executive privilege grounds. Plaintiff's counsel produced an envelope saying, instead, plaintiff's counsel produced an envelope in June that contained all responsive documents. We know that's a lie, but there was no assertion of executive privilege. The records recovered by the government during the August 8th search that bear classification markings are the very records that plaintiff was required to produce on June 3rd, and over which he raised no claim of executive privilege. Having failed to produce documents responsive to a lawful grand jury subpoena, plaintiffs should not be rewarded with an opportunity to further delay the government's investigation by interposing such privilege claims now. As the government has made clear, and the plaintiff has never contested, any seized government records, including the seized records bearing classification markings, do not contain any privileged communications between plaintiff and his personal attorneys. The district court's month-long injunction caused and continues to cause significant harm to the government and the public. As the stay panel correctly determined with regard to the injunction against further review and such use of records bearing classification markings, the district court's order created an untenable distinction between permissible use of those records for certain national security purposes and impermissible uses for criminal investigative purposes. And DOJ points us out in the previous brief where effectively Judge Cannon lays a trap for to hold DOJ in contempt later on by micromanaging the uh, investigation and what they could investigate and what they couldn't investigate. The panel thus correctly determined that an injunction delaying or perhaps preventing the United States criminal investigation from using classified materials risks imposing real and significant harm on the United States and the public. Indeed, courts have routinely rejected arguments in criminal proceedings that clear defense counsel are entitled to classified information without the requisite need to know. So, and Donald has shown Donald's counsel has shown no need to know. The district court's injunction barring review and use of the other seized records harms the government and the public as well. A magistrate judge has already found probable cause to believe that those records may constitute evidence of crimes, and the government has demonstrated a clear need for them. Moreover, the public has an interest in the fair and expeditious administration of the criminal laws. Amen. You know, the government's need to proceed expeditiously is further heightened, whereas here it has reason to believe that obstructive acts may impede its investigation, as is happening at the moment, as you know, I think that part DOJ left out. The injunction bars the government from reviewing these records for months until at least mid-December, deadline of the special master's review, and likely well beyond that, pending further proceedings before the district court. And the DOJ has explained that many times in their previous briefs. The injunction further compounds these harms by interposing the court in the government's investigation, prohibit the government from reviewing or accessing the records even for the purposes of evaluating potential charges. The notion that a district court, and this is now DOJ quoting 11th Circuit in Ray Wild, I pointed this out in the previous filing as well. The notion that a district court could have any input on a United States attorney's investigation and decision whether to bring a case is entirely incompatible with the constitutional assignment to the executive branch of exclusive power over prosecutorial decisions in Ray Wild. Finally, plaintiff was not entitled to an injunction for the purposes of safeguarding potential claims of attorney-client privilege because filter procedures already required the filter team to segregate any material deemed even potentially subject to attorney-client privilege. And DOJ in the brief has provided examples of the time when the filter team paused their review out of deference for the court, and they paused and contacted plaintiff's counsel in cases that could be potentially attorney-client privilege, and Donald waived that privilege. And it wasn't a point of waiver, it wasn't something that he claimed privilege over. Thus, even if it were appropriate to appoint a special master to review attorney-client privilege disputes between plaintiff and the filter team, the district court did not need to enjoin the government from review or use of all seized records, or even from review or use of those records already segregated by the filter team. So even if the DOJ says, even if Judge Cannon is right with allowing the special master review, there's no reason for Judge Cannon to stop the DOJ, the executive branch, from conducting its core executive functions, its prosecutorial functions that are based and emanate from the Constitution. In issuing its injunction, the district court stated that the special master process is needed to resolve disputes as to the proper designation of seized materials. In issuing its injunction, the district court stated that the special master process is needed to resolve disputes as to the proper designation of the seized materials. I think I just reread that. Sorry about that. But there are no disputes that could possibly entitle plaintiff to enjoin the government's review and use of the seized records pending special master review, because none of the disputes raised by plaintiff is relevant to potential claims of executive or attorney-client privilege. In describing disputes as to the seized records, the district court cites portions of plaintiff's filing in which he suggested that he could have declassified those documents while he was president. In his myriad filings, however, plaintiff has never actually represented, much less offered evidence, that he declassified any of the seized records. To the contrary, after being asked by the special master to identify any records he claims to have declassified, plaintiff resisted providing any evidence or even any specific assertions. And you may also recall that Judge Cannon intervened and said, no, he doesn't have to do that, stating that such an endeavor would force him to disclose a defense to the merits of any subsequent indictment. So, I mean, we remember him kind of conceding-ish that in his previous filings. Even if plaintiff were to offer direct claims supported by evidence that he declassified any of the seized records, any potential executive privilege claims would fail under both Nixon v. GSA and United States v. Nixon. Plaintiff would still be attempting to assert a privilege against the very executive branch in whose name the privilege is invoked, and the government would still have a demonstrated specific need to review the records as part of its investigation of the potential violations of law. And even if they had been declassified, the records could still be evidence of obstruction of justice, because the grand jury subpoena sought evidence of all records that were marked as classified. So the factual nuance here is that even if they were declassified, if they were still marked classified, that fell within the bounds of the grand jury subpoena that came in June. Moreover, if any records were actually declassified, the government would have an additional compelling need to understand which formally classified records had been declassified, why, and how, in order to evaluate the effects of any such declassification, including on the protection of intelligence sources and methods, and on the classification status of related records or information. So we went through this, that even as I am live streaming this, lives may be in danger because of what Donald Trump has done, because of how he has exposed intelligence sources. The DOJ wouldn't write this if this is not a concern, if this isn't a compelling need, if this isn't a demonstrated specific need. It was plaintiff's burden to establish a possessory interest in the seized records when he brought this suit, and he cannot rely on threadbare insinuations to establish yet another dispute that must be adjudicated before a special master. Plaintiff plainly would not be entitled to return of evidence solely on the ground that the evidence belonged to him when it was seized. If that were the case, evidence rooms nationwide would soon be empty. You understand? And DOJ does this in masterful fashion in pointing out that Donald is not special. And what Judge Cannon has done with the special master review is treating Donald as special on the basis of his former executive office that he held. And doing so is contrary to the rule of law and the public interest. Plaintiff does not demonstrate that the standard filter team process is inadequate to protect his privileged attorney-client communications in the remaining materials. Special master review is unwarranted on that score as well. As the stay panel concluded, by stay panel, DOJ means 11 circuits, 3 judges who denied Donald's, who granted the DOJ's partial stay over the 100 highly classified documents from giving them back to Judge Deary. That's a stay panel. As the stay panel concluded, this court has appellate jurisdiction. So now we're going over to the appellate jurisdiction part of it. Let me just explain to you briefly the jurisdiction part of it. When a case comes to court, and in this case, the case hasn't even come to court yet, but when a case comes to court, it comes to the district court. Assuming that the district court of that particular forum, that particular jurisdiction has jurisdiction over the person and over the matter, meaning the incident happened there, the harm happened there, the person lives there, and there are many factors that go into it. There's constitutional basis, there's diversity jurisdiction, and all of that. But once it is determined that that district court is the right place for this case, the district court has general jurisdiction over the case, meaning all of the facts of the case are determined by the district court. Once the facts are determined, or once, in this case, a partial order or a partial action of the district court that causes the other party against whom that action has been taken irreparable harm, or it causes a sort of a delay in process that would not be cured or it could not be reversed once the whole case is resolved. In such very narrow cases, the aggrieved party can take that issue and take it up for appellate jurisdiction. And that's what Donald has been doing with this appellate jurisdiction argument. Even with the equitable jurisdiction thing, it's sort of interlocutory on a criminal procedure. It's in the middle of something that is ongoing, and it's very difficult to frame this in the context of normal civil procedure, because we've learned everything to happen when a case comes. The presumption is that it's there, it's rightfully there. The fact finding happens. Within the fact finding, if there's a injunction or some sort of an order that one party doesn't agree with, they take it to the appellate court on interlocutory appeal. But here, the whole thing has been sort of made into a mess by this civil proceeding that has overreached into a DOJ criminal investigation, not a criminal DOJ indictment. Okay. The investigation comes before the indictment. If they choose to indict, and once the indictment happens, that's when the district court's general jurisdiction based on the subject matter comes to bear. This is simply based on equitable jurisdiction, which is flimsy, and DOJ points it out in the beginning of the brief. So now let me just go over this equitable jurisdiction part of it. This appellate jurisdiction part of it. As State Panel concluded, this court has appellate jurisdiction through Federal Rules of Civil Procedure 1292 A1, which provides Court of Appeals with jurisdiction over interlocutory orders granting injunctions. The district court's September 5th order enjoined the government from further review and use of any seized materials for criminal investigative purposes pending resolution of the special master review process. So that is an injunction. And that itself is reviewable. The special master review process, directed by the district court in the same order, is also improperly before the district court on multiple independent reasons. First, this court has pendant jurisdiction to review a district court's order requiring review by a special master of the seized records and of plaintiff's purported privilege claims, because the court's order to address an otherwise non-appealable order is inextricably intertwined with the appealable decision. And I've discussed this in the previous videos and from the explaining the filings, that the issue is inextricably intertwined with the whole. Everything is intertwined. It makes it very difficult to explain, let alone write. But DOJ is just, it's masterful. Second, the plain text of the Federal Rules of Civil Procedure provides that Court of Appeals shall have jurisdiction from interlocutory orders of district courts granting injunctions, what I explained before. It is thus the entire order that is appealable, not just particular issues within the order. Okay? Third, even were this court to conclude that neither the text of the statute nor pendant appellate jurisdiction provides basis for review, this court would be at the very least, have jurisdiction to consider the portion of that order requirement documents bearing classification markings to be disclosed in the course of the special master review. That is because an order to disclose classified information is immediately appealable as a collateral order. And I explained the collateral order thing in the previous episode also. Such an order that is, is irreversible. And I'll read this instead of explaining, because the DOJ does a much better job. Such an order conclusively resolves an important question separate from the merits of the case. In this case, the merits of the case being all the other investigative things that are happening. And it is effectively unreviewable on appeal from the final judgment in the underlying action, because such disclosure once made is irreversible. So essentially saying, once you send the stuff to the special master, it's irreversible. It's like the review is done. All of the investigations and the compromising of the investigation will have happened. You will have destroyed national security, and the irreparable harm will be to our national security, the public interest, and the rule of law, all because of Donald feels that he has, in one of his filings, he said unquantifiable potential harm. Okay. And lastly, the DOJ says, if the court harbors any doubts about its jurisdiction over the portion of the September 5th order, it should construe the government's appeal and stay motion as a petition for a writ of mandamus with respect to those portions and grant of petition. So this is another alternative grounds for which the DOJ says the 11th Circuit can, rule and maintain the status quo of the government and the Article 2 branch of government conducting its investigations. So now we wait for Donald to reply to this. I assume the reply is going to be something very close to what he has replied to many times before, and we should expect to at least know when the oral arguments will be by Thanksgiving, which is about a month away. It's an astoundingly well-written brief, as usual. And hey, I'm going to look at the chat. Hey, Martine, thank you so much for being here. I appreciate you very much. And so that's all for this episode today. Thank you so much for being here. And if you haven't liked or subscribed, if you did like, please like and subscribe. All right? Take care.